Welcome to our 650 webinar, COVID Policies, a look forward and a look backward. My name is Ryan Parker. I'm the Chief Legal Product Officer here at 650. And with me today on our panel, we have Marie Colbeth and Adam Wright, and I'll introduce them in just a minute. For those of you that haven't heard of 650, we're the legal technology subsidiary of the law firm Wilson Sonsini. And we are helping businesses with privacy solutions in CCPA, GDPR, the new PIPL regulation in China, and also in the employment realm with a return to worksite tool set that's helping businesses of all sizes, ranging from enterprise businesses to small businesses, to keep their employees safe. We help businesses to generate COVID-19 policies, to screen employees before they report to the workplace, and to keep up to date on the different and moving regulations with COVID-19. We also help companies to create employee handbooks, and we have also an employment agreements tool. And so as part of that, we are watching COVID-19 policies quickly and working with hundreds of different companies on their COVID-19 policies. And as we've done that, we have noticed some different trends and some best practices that we're excited to share with you today. If you're interested in learning more about what we do at 650, feel free to visit us at www.650.com, and we will put more information about where you can learn more about our products if you're interested in the chat as we go through this webinar. Now let me turn to introducing our co-panelists. First, we have Marie Colbeth. Marie, in addition to serving on our legal product team, also serves as our general counsel. Marie graduated from one of the top law schools in the country, clerked in the Fifth Circuit, and you'll hear more about the Fifth Circuit later in our webinar, and worked at the university before joining us as general counsel at 650. In addition, we have Adam Wright. Adam attended what I think is the best law school in the country, Go Blue, the University of Michigan, before clerking for 2 federal judges in North Carolina, before working at multiple law firms, and then joining us here at 650. And both have a lot of experience looking at COVID rules and regulations. So today on our webinar, as we said, we're going to look first back a little at where we've come from, and then forward at maybe what the future holds here in COVID-19 policies and ways that businesses are taking steps to protect their employees from COVID-19. Specifically, we'll talk about the Supreme Court's decision on the federal emergency temporary standard that just came out recently. It has certainly shaken up the landscape of COVID regulations, and we'll talk a little about that. A big question we're getting, are vaccine mandates still allowed after the decision? We'll talk about that. Have masking rules changed? How to handle exemptions and accommodation requests? That's something that we get a lot of questions about from customers and also on our webinars. And then record keeping requirements and best practices. And so we'll start by looking back, we'll look at the current situation, and then we'll look forward. Before we dive into the content of the webinar, let me just answer a couple of questions that we typically get. One, the slides for this webinar will be sent out to you after the webinar. Two, if you have questions, please put them into the Q&A at the bottom of your screen. It's a lot easier for us to track those questions and to answer them live through the Q&A function rather than putting them in the chat. So please put your questions there. We'll answer some of them as we go along, and we also have allotted some time at the end for questions. So feel free to chime in. With that, let's jump right into a quick COVID timeline. And we won't spend a lot of time here, but I do think it's interesting. December 31st, 2019, the first case of COVID-19 was reported to the WHO. And then 2 years ago today, so this is a COVID anniversary day, the first laboratory confirmed case of COVID-19 in the US was reported in Washington State. Hard to believe that that was only 2 years ago. March 11th, so not that much, just a couple months later, even less than a couple months, the World Health Organization declared COVID-19 a pandemic, and the NBA shut down after Utah Jazz player Rudy Gobert tested positive for COVID. And for us, we're a company that's based in Utah. That was a real eye-opener, and we went remote following the news about COVID-19 on March 11th. On March 13th, President Trump declared a national emergency. And within days, the New York school system, the largest school system in the United States with over 1 million students, shut down. And states across the country started to put rules in place to combat COVID-19. In April 20th, 2020, the CDC recommended that people wear masks outside their homes. And that was a change from the guidance we'd had previously, and masks became a serious and continuing issue for businesses to deal with. Let's move to the next slide. In May 20th, 2020, the US COVID-19 death toll surpassed 100,000. So very quickly, from January to May, we had the first 100,000 deaths from COVID-19, and that death toll has continued to climb. In November, California's OSHA issued their emergency temporary standards. For those in California, you're very familiar with the ETS. California really was a leader in COVID-19 rules and regulations, and its ETS really became a model for what became the federal ETS that we'll talk about a little later. December 14th, 2020, in a glimmer of hope, a nurse in New York becomes the first American to receive a COVID-19 vaccine outside of a clinical trial. And within about 10 days, 1 million people had been vaccinated. In May of 2021, New York enacts the HERO Act, or it's signed into law, requiring businesses to adopt a safety and health plan. Another step taken by New York. And one of the trends that we'll see is that California and New York really led out in passing rules and regulations and working with other states on ways to combat COVID. In June, the Delta variant becomes the dominant strain of COVID-19 in the United States. But as we'll see in the next slide, that doesn't last for long. On November 5th, OSHA publishes its emergency temporary standards, which are applicable to businesses with at least 100 employees. Those standards are immediately challenged in federal courts across the country, and we'll talk more about that. In December, Omicron becomes the dominant strain of COVID-19 in the United States, and by January 11th, the US reports record numbers of new COVID cases, over 1.3 million cases reported in a single day, and hospitalizations due to COVID-19. And so here we are, almost 2 years into the pandemic, and we hit sort of these high points of both cases and hospitalizations. And then on January 13th, 2022, the Supreme Court enters a stay, essentially pausing the federal ETS while the legal challenges proceed. And that's where we stand. We're in a position where we have lived with COVID-19 for almost 2 years, and we've seen a lot of ups and downs. Let's look right now, just for a moment, at some of the trends that we can take from the timeline before we dive into the ETS. So one of the trends certainly is that the threat posed by COVID-19 continues to evolve. That we're now, we've moved from the initial strain to the Delta variant to Omicron. We're learning more and more about vaccines, about masks, and we're seeing a lot of changes. Another trend is that businesses must track multiple layers of changing guidance. We saw in the timeline guidance from the CDC, the Centers for Disease Control and Prevention, from OSHA, from the EEOC. States like California and New York are sort of setting the trends for other states. And locally, we're seeing counties and cities passing different guidelines. I know I live in Maryland, and Montgomery County, for example, has a mask guideline that requires people to wear masks in businesses. And so businesses are really being required to follow federal, state, and local guidance. And those guidance, that guidance changes regularly. And finally, businesses continue to be faced with uncertainty because of these changing circumstances. We saw this particularly with regard to the federal emergency temporary standards, where on January 11th, we had some of the deadlines pass, and companies had to have different plans while the case was in front of the Supreme Court. And on January 13th, the Supreme Court entered a stay. And so we have these situations where businesses are faced with uncertainty because of changing circumstances, changing laws, and legal challenges to the laws and regulations that they're subject to. And I think all of this adds up to a situation that is extremely challenging for businesses as they are trying to keep employees safe while monitoring changing trends and regulations and all of these different developments. And so this is a situation I think that really presents an unprecedented challenge for businesses. and it's a challenge that looks like it's likely to continue. And later on, Marie will talk to us about some best practices that we can put in place as we confront these challenges. We talked earlier about the ETS, and this has kind of been the big news in the COVID-19 regulations over the last few weeks. So let's look at the road to the Supreme Court, how we got here. On November 5th, 2021, the Federal Emergency Temporary Standard was published by OSHA. And that was a standard that had been announced a couple of months before by President Biden. And it's one that requires businesses to adopt policies that either require their employees to be vaccinated or regularly tested for COVID-19. The standard applies to businesses that have 100 or more employees. And if you're interested in more information about the federal ETS, we did a previous webinar on that we can link to, where we really went through in detail all the provisions of the federal ETS. But that federal ETS was published on November 5th. A wave of lawsuits were filed in circuit courts across the country. OSHA provides that the ETS can be reviewed directly in the circuit court, so they were not filed in federal district courts or trial courts. They are filed in the federal circuits. And within a day, the U.S. Court of Appeals for the Fifth Circuit, where Marie clerked, entered a stay of the ETS. The Fifth Circuit is generally considered to be the most conservative circuit in the United States, and they quickly stayed application of the ETS. Because there were cases filed all over the country, the Judicial Panel for Multi-District Litigation stepped in, and it took all of the cases and consolidated them into one action. And then in what really looked almost like a Powerball drawing, they put ping pong balls with the name of each circuit into a bucket and pulled one out, and it was the Sixth Circuit Court of Appeals. So the Sixth Circuit Court of Appeals, which covers Michigan and Kentucky, kind of the middle of the country, was chosen to hear all of these consolidated cases. They heard the cases, and on December 17th, the Sixth Circuit dissolved the Fifth Circuit's pause on the ETS. So they said, no, we're not going to stay the application of the ETS while these cases continue. It can still take effect. Companies still need to comply with it, and we'll move forward with that. And the parties challenging the ETS immediately appealed that ruling up to the Supreme Court. And so by the time it got to the Supreme Court, we'd had one ruling by the Sixth Circuit, or the Fifth Circuit, excuse me, that the ETS should be stayed. We'd had a second ruling overruling the Fifth Circuit's ruling by the Sixth Circuit saying it should go forward, and the issue was teed up for the US Supreme Court. The US Supreme Court heard argument on the case, and if we can move to the next slide, and it was clear that some of the conservative justices on the court had concerns about letting the ETS take effect. And then on January 13th, 2022, the Supreme Court published a lengthy decision staying the ETS while the cases continue in front of the Sixth Circuit. The decision was 6-3, largely along ideological grounds, with Justices Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett voting to stay the ETS, kind of joining with the decision of the Fifth Circuit, and Justices Breyer, Sotomayor, and Kagan dissenting. And so as part of the decision in determining whether to enter a stay, the Supreme Court, really one of the most important factors was the likelihood that the plaintiffs would succeed in their challenges. And the Supreme Court ruled pretty explicitly that they found that the challengers were likely to succeed in their challenge, and they entered a stay. The consolidated cases were then sent back to the Sixth Circuit to be decided on the merits. And so the Sixth Circuit will continue to look at the briefing, may hold argument, and will come out with a decision. But I think that no matter what the Sixth Circuit decides, the case is likely to go back to the Supreme Court. And the Supreme Court has already forecast how it is likely to rule, and that's to strike down the ETS. And so at this point, it appears unlikely that the federal ETS will ever go into effect. There's still litigation that could happen and things could change, but based on the Supreme Court's decision and the 6 justices who joined a decision saying that it was likely that the plaintiffs would prevail in their claims to strike down the ETS, I think it's very unlikely that the federal ETS will take effect. And that has, I think, had some interesting ripple effects, and Adam is going to talk a little bit more about those, but we have states that had adopted the federal ETS into their own state laws. We have companies that had already complied with the ETS, and we've seen at least one large company, I think Starbucks, has said they're no longer going to require vaccinations. And so the Supreme Court's decision really has had already a significant effect on the landscape of COVID-19 regulations, and I think is likely to continue to affect those regulations as the states are left to, and businesses themselves are left to step up and sort of fill this void that would have been filled by the federal emergency temporary standards. And with that, I'll turn the time over to Adam to look at our current state. Now that we've looked back, let's look at where we are now and to address some of those issues.
Thanks, Ryan. So yeah, one of the big questions that we're seeing a lot is, what about employers that want to have a vaccine mandate in place for their employees because for whatever reason they think it's the best practice, the best way to create a safe working environment for their employees. So what are companies in that position supposed to do? And I think we already had a question about this in the chat. So really, the Supreme Court's decision didn't change employers' ability to voluntarily implement a vaccine or testing requirement. The Supreme Court's decision was really limited and focused on OSHA's power to implement the ETS. And that's what the Supreme Court found was lacking. So again, it said nothing about private employers or even state or local jurisdiction ability to implement a vaccine or testing requirement. So the short answer is, if you're a company in that position, you can still implement a vaccine or testing requirement. If you do that, you'll want to have in place, obviously, reasonable accommodations for things like disability or sincerely held religious beliefs. And Marie's going to talk a little bit about that later. But we've seen businesses across the country that have voluntarily implemented vaccine or testing requirements as a best practice. So companies are still permitted to do that. Now, there is one big caveat to that, and that is if you operate in one of the 11 states listed here. So Alabama, Arkansas, Florida, Iowa, Kansas, Montana, North Dakota, Tennessee, Texas, Utah, and West Virginia. Each of these states has implemented laws that either limit or ban private employers' ability to implement vaccine requirements. And we're going to talk a little bit about these in more detail. But if the ETS had remained in place, it would have been likely that these laws would have been preempted by the federal ETS because they are in conflict with the ETS. And so they probably wouldn't have been enforceable. But now with the ETS appearing doomed, we're left with this patchwork of laws. So if you are a company that operates in different states and you want to have a vaccine mandate or vaccine requirement for your employees, this legal landscape really makes things a little bit more complicated. And these states passed their laws limiting vaccine mandates largely in response to President Biden's executive order when he called on OSHA to put in place a vaccine or testing rule. As of now, these state laws that limit private employers' vaccine mandates are still in effect, although we do expect to see legal challenges to them, especially now since the ETS is not looking like it's going to survive. So stay tuned for legal challenges to these state laws, and now we'll take a look at some of these state laws in more detail. There are 3 states that have either directly or indirectly banned private employer vaccine mandates. And as we'll see, Montana is the only state that's really done that explicitly. Texas and Tennessee don't expressly prohibit private employers from putting into place vaccine mandates, but they put other restrictions on them that are so broad that in effect, they really work as bans on private employer vaccine mandates for employees. So let's talk about Texas first. So there, Governor Abbott issued an executive order that prohibited any entity in Texas from compelling employee vaccination if the employee objects for any reason of personal conscience, based on a religious belief, or for medical reasons, including prior recovery from COVID-19. Now, this executive order does 2 pretty notable things. The first is that it provides an exception for any reason of personal conscience. So that exception really is so broad that it works in practice as a ban on vaccine mandates in Texas, because an employee can object for really any reason to avoid an employer's vaccination policy. The executive order also does something interesting by including prior recovery from COVID-19 as an exception. as an opt-out reason. And so that really goes far beyond sort of our general understanding in the legal field of what a medical reason might typically exempt an employee from a vaccine requirement. Businesses that fail to comply with the executive order may face fines up to $1,000. So there are some real risks associated with violating the order. This Texas law, or the Texas ban, I should say, differs from all the other states we're going to talk about that have limited or banned vaccine mandates, in that it comes in the form of an executive order as opposed to a state statute that was passed by the state legislature. And that the consequence of that is that it potentially opens up the executive order to some additional challenges that aren't present for state statutes. So interestingly, Governor Abbott in the executive order called on the Texas legislature to pass a law implementing a vaccine mandate ban, but there was some pretty vocal opposition to that by the business community in Texas. And so the legislature actually didn't act. And so in Texas, we're just left with an executive order as opposed to a state statute. So again, that opens up the ban to, or the limitations on vaccine mandates in Texas to some additional challenges. One of which is that Governor Abbott exceeded his executive authority because the governor doesn't have the power to regulate private employers in the state in this way. So again, we haven't seen specific challenges to the executive order in Texas yet. We expect to see some, which will be really interesting to watch. So again, stay tuned for that. So for Texas, or for companies that have employees in Texas, if you want to implement a vaccine requirement, you can ostensibly have one, but at this point you would need to include that exception for any reason of personal conscience. So, question whether a vaccine requirement with an exception like that is really a requirement at all. Montana is the state that has explicitly banned COVID-19 vaccines, also, although they've done so only for vaccines whose use is allowed under an emergency use authorization or any vaccine undergoing safety trials. So presumably vaccines that have received full FDA approval, like Pfizer, would not be included in that ban. But whether that explicit ban remains in place in Montana doesn't really matter because of another approach Montana has taken, which is it's the only state that's done this so far, but Montana has added vaccination status as a protected category under its state civil rights law. So really, employers in Montana can't make any employment decisions, hiring, firing, terms of employment, based on vaccination status. So again, even if the explicit ban on COVID-19 vaccine mandates is gone in Montana, employers are still left with this prohibition on discriminating based on vaccination status, which is, again, works like a ban on vaccine mandates. Tennessee, like Texas, has taken sort of an indirect approach to banning vaccine mandates. They don't do it explicitly, but they prohibit employers from requiring proof of vaccination status, and they prohibit employers from taking any adverse action for an employee's refusal to provide vaccination status if the employee objects to receiving a COVID-19 vaccine for any reason. So employers can still ask employees to voluntarily provide vaccination status, but if they don't, the employer can't take any adverse action. So again, like in Texas, while it's not an explicit ban, an employer that can't require proof of vaccination probably isn't going to have an effective vaccination policy. All right, so let's move on to talk about some states that have taken maybe somewhat more limited approach to their to scaling back vaccine mandates by private employers. So these other states are listed here at the top. These states have the laws that they are implementing. They typically cut into the effectiveness of vaccine requirements by adding to or enlarging the available exceptions to vaccine mandates. So you may be familiar with exceptions under federal law, which we've talked about briefly, but those are things like disability or sincerely held religious beliefs. These states, the laws in these states are notable in how they have expanded those exceptions. So this is not an exhaustive list, but it will give you, I think, a good sense of the flavor of what these states are doing. And so if you have employees in these states, you need to be really careful about the type of vaccine policy that you are implementing. So in Arkansas, Florida, North Dakota, and West Virginia, those states require an exception to a vaccine policy for proof of immunity. So for example, showing you have COVID-19 antibodies, and typically those require a certification from a healthcare provider. These states provide that exception despite the fact that the CDC recommends vaccination even for people that have positive antibody tests, because that test alone doesn't necessarily mean that a person is immune from COVID-19. West Virginia takes it a step further, as Texas did, and it allows employees to show that they to opt out of a vaccine requirement by showing that they previously had COVID-19. And this is notable because there is no time restriction on that. So, presumably an employee could show that they had COVID-19 a year and a half ago, and they would, based on that, be able to opt out of an employer's vaccination policy. Florida also has an exception for use of employer-provided personal protective equipment. So if an employee wants to wear PPE instead of getting vaccinated under Florida law, the employer has to let them do that. Utah and North Dakota have taken interesting approaches and added pretty broad exceptions. So in Utah, employers have to provide exceptions for sincerely held personal beliefs. In North Dakota, there has to be an exception for philosophical or moral beliefs. And now these are pretty new terms in employment law, so it really remains to be seen how courts are going to interpret them. Well, we don't know yet exactly what these exceptions mean or how employers are supposed to evaluate requests for exemptions for personal, philosophical, or moral beliefs. And I think there's a significant chance that these exceptions are so broad that, kind of like the Texas law we talked about, they're going to be so broad that they really swallow the rule and undercut any vaccine requirement that an employer puts in place. And then finally, an approach that all of these states have taken basically is to broaden religious exemptions. So unlike under federal law, where an employer can ask some limited follow-up questions about an employee's claimed sincerely held religious belief, in these states, typically, if the employee provides a signed statement, sometimes it has to be notarized, but if they provide a statement that says they oppose getting the vaccine based on a religious belief, then that's going to be sufficient alone to opt out of the employer's vaccine mandate, and employers can't really ask follow-up questions. So if you have employees in one of these states, it's important that you provide for these exceptions if you have a vaccine mandate in place. So let's move to the next slide. And I'll just say one final note on vaccine mandates. So with the ETS appearing like it won't survive, it's possible that states or local jurisdictions are going to step in and potentially mandate vaccines for private employers. We've seen New York City do this already. We haven't seen any indications of movement like this at a state level yet, but I just wanted to note that there's really nothing in the Supreme Court's decision that addressed that issue. And so there's nothing in the Supreme Court's decision that would prohibit a state from doing that. There may be other issues or other legal reasons that states run into problems with that, but the Supreme Court's decision itself isn't going to stop states from implementing that if they want. And so far, the Supreme Court has been pretty friendly to state level vaccine mandates. You can see a list here of justices across the political spectrum that have declined emergency requests to block state level vaccine mandates. Now, none of these mandates broadly applied to private businesses, so it's unclear how the Supreme Court would deal with that. But it's something that you want to keep an eye out on for any possible state mandates that will be coming down the pike. All right, let's transition briefly just to talk about masking requirements just for a second. Masking requirements present unique challenges for employers operating in multiple jurisdictions. Not only do employers need to look at state level requirements, but as Ryan mentioned, they also need to be aware of local requirements. So first off, I just say there's nothing that prohibits employers from implementing a mask requirement or from treating vaccinated and unvaccinated employees differently by requiring unvaccinated employees to wear face coverings, as long as you're providing reasonable accommodations. The one caveat to that is Montana, which we talked about. because Montana has included vaccination status as a protected category under their civil rights law, employers can't treat vaccinated and unvaccinated employees differently, for example, by requiring unvaccinated employees to wear face coverings. But Montana employers could require all employees to wear face masks. Another headache for companies is when there are competing state and local masking requirements, and there's probably no bigger headache for employers than Texas, where you have an executive order banning local jurisdictions from requiring masks, but then you have local jurisdictions like Harris County, where Houston is located, flouting the executive order and requiring private businesses to mandate masks. This particular dispute is right now in active litigation, but most recently a Texas appeals court ruled that the county could implement a mask mandate despite the governor's executive order, but that decision is being appealed to the Texas Supreme Court. But again, this is an area where employers need to really be careful and where competing state and local requirements cause a lot of problems for companies and make it very difficult to know how to proceed. And in these cases, ultimately it will probably come down to they will be litigated and it will be the result of litigation. All right, so in addition, it's also important for employers to stay on top of local requirements where your company operates. There's really too many local mask mandates across the country to talk about them all here today, but these are just a few examples here. So in California, for example, you have a statewide mandate for indoor public spaces that is in place through February 15th, but the statewide mandate had an exception for counties that already had masking requirements in place, and it allowed those local requirements to remain in place. So employers are going to need to obviously be aware of the statewide masking rule as well as the local jurisdiction rules. Some examples of counties in California that have their own rules are Alameda, San Diego, Marin, and Santa Clara counties. LA County also requires employers to provide employees with medical grade masks. So this just gives you an example of the varying requirements across local jurisdictions that you're really going to need to be paying a lot of attention to. A couple other examples, Utah and Maryland, neither of them have statewide mandates in place right now, but both have specific counties. I think Ryan mentioned Montgomery County, and in Utah, Salt Lake and Summit counties have their own mask rules in place for indoor public places. And so again, this is a sort of fluid area of the law that's changing quickly as the science changes and with potentially conflicting requirements at the state and local level. And so it's a difficult area of the law for employers to operate in, but something that's really important to stay up to date on. All right, I'm going to turn the time over to Marie now to talk about some additional steps that companies can take relating to COVID policies.
Thanks, Adam. And what we've been talking about so far is so relevant to what we should actually be doing on a go-forward basis at our companies. One that you just mentioned actually is really relevant to me. Our offices are in Salt Lake County, and Salt Lake County actually put in place not just a mask mandate, but it was a mask mandate that was moving towards a respirator mandate, like with a timeline for when we had to be using respirators. But 2 days ago, the legislature just opened, and they, in the Senate, passed an emergency resolution to counteract that mask mandate. And now it's going to the House. So like, we're watching the legislative session to see what happens with our mask mandate. And things like that are happening in jurisdictions all across the country. So knowing what to do to be both compliant and how you can be compliant and keep your workforce safe are, very important things that we're all really worried about doing. And a lot of the questions I've been seeing coming into the chat are talking about the differences across, what if I have employees who are based in one place, but I need to send them somewhere else? How do I navigate that? And we're going to get into that in just a minute. I wanted to start talking about accommodations. I think as we move forward and as we have this changing legal landscape where, we're not really able to rely on the ETS at this stage, it's stayed. And so we don't know if at some point it may go into effect or not. So, relying on it to say like, okay, well, we're just going to look to that to decide what to make our policy it doesn't really work because we now have these competing state laws, these jurisdictions. Could we advance to the next slide, please? And so as we have these jurisdictions putting in place new rules, we need to start thinking about, okay, if we're going to have a policy in place, specifically, especially a vaccine policy, then we need to think about what accommodations we're going to allow. And as we allow those accommodations, we need to think about both what's required from a federal perspective and what may be required from a state perspective. And so I wanted to kind of talk us through first that federal perspective, because it applies to everybody. It applies to your workers no matter where they are. And so sort of the base level that we should start at is, what is a reasonable accommodation? And a reasonable accommodation is when you make a change in the work environment or the way things are usually done in your workplace to enable a qualified individual to enjoy equal employment opportunities. And of course, the question is, well, who's a qualified individual and what is meant by equal opportunities? And there's different laws that make different individuals qualified for accommodations in different circumstances. Typically, what we need to do as we think about, who is it going to apply to, we think usually about two different rules: the Americans with Disabilities Act, the ADA, and Title VII, which is your civil rights protections. So under those two, with those two, we have two different groups. We have people with disabilities. We have people with so physical or mental impairment, or people who may just be regarded as having that type of impairment, even if they don't actually have it. And then under Title VII, we have people, typically the exemptions we're looking at, or accommodations I should say, are for religious or sincerely held beliefs. And we need to really focus on the fact that under Title VII, this is specifically religious belief. It's not political belief, it's not social or economic philosophies or personal preferences. It has to be based on some sort of religious belief. That doesn't mean it has to be tied to an organized religion, but it does have to be a religious belief. And it also doesn't mean the organized religion overall has to embrace the same belief. So an example we might give here when talking about COVID-19 is, so just sort of an example that touches a lot of people across the world. The Catholic Church is an organized religion, and in times past, many people who are members of that church have, taken issue and looked for accommodations from rules if there's, something that has relied on the use of fetal cells and development of different, medications or other health technologies. And so they've looked for accommodations in those situations. And now we have a situation where the Catholic Church, the leader of the Catholic Church, the Pope, has said, in this specific instance, because of the nature of the pandemic and its threat to life, people who use the vaccines that may have had fetal cells used in their development, they're not in direct, opposition of our church's stance on the use of fetal cells. And so, the church overall might have taken that stance, but an individual who's a member of that church could still take a different stance and be eligible for a reasonable accommodation. So it can get really tricky as we get down into the weeds, is what I'm trying to say. And so what we wanted to talk a little bit about is, what does that mean for you as a company when it comes to deciding what can we ask as we decide who to make accommodations for, who to grant exemptions to. And I was actually just on a conference call with general counsels at tech companies across the United States this week, and we were talking about the same question. And some companies wanted to go in the direction of asking more and saying, like, we want to really make sure that it is based on a religious belief. And other companies are sort of taking the approach of, well, we don't really want to delve into that too far. But you may have a workforce where you have a lot of people looking for an exemption. And so some companies in that space are saying we need to delve a little further. And this is where there's actually a case, it's not a case, a situation that some of you may have read about in the news. There's a health system in Arkansas that has an attestation form that says, okay, if you're asking for an accommodation based on religious belief, we want you to also attest that if your religious belief is based on the fact that fetal cells were used in developing the vaccine, we want you to attest that you also don't use Tylenol or aspirin or Motrin, ibuprofen, Pepto-Bismol, any of these things that also use similar research methods. And that's a really detailed form. And so we were kind of talking about the ins and outs of that and whether you can ask that question. Can you do that? And there's not a clear answer from the perspective of federal employment law, because what happens is essentially the EEOC has said that if you as the employer have a bona fide reason to doubt the basis for the accommodation request, you can make a limited inquiry into the facts and circumstances around that employee's claim for an accommodation. And so it's like, okay, well, what's reasonable? That's always the question, right? What's reasonable here? And so you can ask, questions about the belief and practices at issue. And then they list some factors of, what you can take into account. And the main issue here is they're all just factors. None of it's dispositive. And so you should be very cautious in resting your determination about whether an employee's belief is a sincerely held one based on evidence about whether they've previously acted consistently with that belief. It can really cut both ways. So being careful from the perspective of federal employment law, but also being careful because you may have these competing state rules that Adam was just talking about that are in place where it may not matter in some states whether it's a sincerely held religious belief, because the state may have expanded the protections to say a philosophical belief counts, personal conscience, or if you're in states where you're not allowed to do that further inquiry, then you should not be asking these further questions because you're listing information you don't really need, because it doesn't matter. You just have to accept the belief in whichever direction the employee is saying to you that they believe. So it can be really tricky there. And if you're trying to implement a policy that covers multiple states, you may just need to have specific state carve-outs. I know we all want simple state policies that allow you to do the same thing everywhere, but that may just not be possible right now. And so that's one of the things we talk about and we address, in our tools that we give to our clients who are using our tools to create their vaccine policies. As you decide what our accommodations going to be, what exemptions are we going to allow? So, sometimes somebody may be, just exempt. We're not going to be able to do anything. But in those situations, the question is, well, what's reasonable? What could we do to accommodate them? And keep in mind that an accommodation may be reasonable under the ADA and not under Title VII and vice versa, because they use slightly different definitions. Yay, it gets more confusing. So if you say somebody's asked for an accommodation, but it's too much of a burden on us, under Title VII, it's more than a minimal burden. Under the ADA, it's significant difficulty or expense. Those are the things that would take you past that line of, being an undue hardship. And so we thought we'd talk for a minute about, practically speaking, what could that look like? What could we do that would not be considered an undue burden on us? So if we could go to the next slide. So things that you could do, if you have a vaccine policy in place and you need to make accommodations for employees, you could implement a testing policy. And this is where the ETS is actually still really helpful, even though it's stayed right now. It gave great information around how to create, a testing policy, so a vaccinate or test policy. So even if you're not saying to your employees, you all have the option to either get vaccinated or submit to weekly testing, you could say to them, we have a mandatory vaccine policy. For those that are getting exemptions that need reasonable accommodations, we're going to allow you to submit to testing as your accommodation. So if you, pass your test once a week or however often you decide to implement it, you can come into the office. One of the tricky things there might be accounting for availability of tests in the areas where you actually have employees. They've gotten difficult to obtain in some places. So do think through that as you're deciding whether to make that your accommodation. You also need to decide and put it into your policy who's going to pay for the testing so that the employees know if that's what they're choosing as their accommodation, whether they're taking on, the burden of needing to pay for their own tests. Remote working for those companies that are able to do it remains, a great accommodation. With that, you may do primarily remote working, but maybe have days in and days out options where again, maybe they submit to testing so they can come in for a limited number of days after they've had a test, but then they're not allowed back in the office until they've had another test. So there's ways you could combine some of these options that can, be really effective. And again, as you're doing this, you need to think about, what can we do outside of these activities? So testing obviously does have a lot of practical burdens, both, administrative burdens for the company and for the employee with their time, having to go get the test, the potential cost of it. Limiting their interaction with others on the site might be something that you could do fairly easily in some situations. So, keeping their same job description, but maybe adjusting the physical location. Maybe traditionally they worked in a bullpen where everybody, it's open access, they're at cubicles. And now you might be able to move if you don't have too many, some of those employees into offices where they're alone. So they're not interacting with other employees if they're not vaccinated, at least not interacting as much. So again, improving the overall safety while providing an accommodation for the employee. It may involve changing job descriptions to allow the company to meet safety concerns. And I saw this come up a lot in the chat. I was actually on a call with somebody who they work with schools across the country, and they send representatives from their business to those schools. And depending on where you are, there may be really strict rules in place about who can, be on campuses right now. And so they've adjusted job descriptions where, before a lot of people had, oversight over certain regions. And now they've sort of adjusted it and said, if our employees who need to go on site are not vaccinated, then we may assign some schools within the region to somebody else, and we may assign them some schools from that person's region where they don't have those rules in place. So making adjustments based on the practicalities of your business. But again, keeping in mind that as you make those accommodations, you shouldn't be infringing upon or changing the person's, job title. You shouldn't be, demoting them. Those things lead to discrimination claims when you're deciding what accommodations you might offer to somebody. So be careful with that. But, you can also implement rules around your common spaces. So keep limits on how many people can be in a space at a time. Take those physical steps you may not have taken. So if you've been closed, but now you're trying to go back and you never did take steps to improve the ventilation, to get a HEPA filter, to do those types of things. Those are great safety moves to make regardless of COVID, right? So think about that. And then of course, requiring PPE. So at the end of the day, Adam made the comment, in some places you can't even inquire about whether somebody's vaccinated. Well, you can always just treat everyone as unvaccinated and say everybody needs to wear PPE. Or if you are allowed to inquire, you can say, all of our unvaccinated employees need to wear PPE. And at this stage, I think, with Omicron, saying that PPE needs to be a respirator, at least at this stage, is a good move towards a higher safety standard than just a cloth mask if you're worried and you're not able to get everybody vaccinated in your workforce. So those are some of the things that we would recommend as potential accommodations that you can make. As you do that, just be aware that at the end of the day, communication with your employees as you go through these steps is really key, and having a good relationship with them and helping them see that you're trying to do what you can to keep their coworkers safe as you're recognizing any exemptions they may be claiming. Help them understand that you care about all employees. And that will make a difference, I think, in coming to an accommodation that really works. So next, we're going to address record keeping. We had a couple of questions come up about this in the chat. One of the main ones was, do I need to, continue doing only, pictures where I'm scanning or taking pictures of people's cards? Or at this stage, can I just go back to self-attestation? So if we could advance one slide. And the answer to that one is that self-attestation versus having an actual copy of the vaccine card, the reason that became an issue was the ETS. The ETS only allowed self-attestation as like a last resort if somebody really couldn't get a copy of their vaccine card. But now with the ETS stayed, that is no longer really as much of a concern, at least, if it does go back into effect, you would have to pivot to getting an actual copy of the card if you do self-attestation right now. So that's more of a preference that the company may or may not have. One thing I wanted to focus on is just the need to keep all medical records separate from people's personnel files. You have to keep them confidential, which means limit access to them to people who have a job-related need to access those copies or self-attestation forms, and only disclose them either to the individual themselves. So if somebody asks you who gave you a copy of their form, you say, I want to see it, you disclose it back to them, or as required by law. So if you are in a jurisdiction where they may be requiring you to collect vaccine information about your employees, so say, for example, New York City, I should say, you may need to disclose to show that you've done your record keeping and you've actually checked people's status. In terms of retention, OSHA has a 30-year medical record retention rule. So if you have a copy of the actual vaccination card, it's subject to a 30-year retention rule. The ETS had created an exemption where it's like, you don't have to keep it for 30 years. But since the ETS has stayed, technically that exemption has also stayed. So that's a really interesting nuance. We'll see if OSHA comes out with something to say like, the ETS was stayed, but we are going to allow that 30-year record retention rule exemption. We haven't heard anything about it yet, so we'll see. But if you're worried about the 30-year rule, self-attestation forms are not considered medical records under OSHA, so you wouldn't have to keep that for 30 years. The ADA does have a 1-year medical record retention rule, and a self-attestation form does count as a medical record under the ADA. So you'll have to keep them for at least a year, potentially longer if you have any sort of litigation or something going on where you need to keep the records. But hopefully we'll end up with an exemption from that OSHA rule in either case. But for now, technically the exemption has stayed, so you do have to keep copies of vaccine records for 30 years. Unless you're in California, their exemption is part of their ETS, and so that one is not stayed. In California, those copies are not considered subject to the 30-year rule. So that's record keeping in a nutshell. And then we just wanted to hit really quickly on some best practices overall. The main thing is that you need to have a written COVID policy. If you don't have one, now is the time to get one. We can help you with that at SixFifty if you want to create one using our system. One thing that I always say that a lot of companies haven't really thought about is, communicate your values to your employees, like why you're doing this. I think that early in the pandemic, a lot of us said, we're doing this because we have to. Legally we're required to make you wear a mask, or legally we're required to make you quarantine right now. But at the end of the day, as we're in a place where there's all these competing legal requirements in different jurisdictions, and you may be operating in multiple jurisdictions, I think if you can really clearly communicate what values you're trying to uphold in terms of why you're making the policy decisions you are, it really will help your employees to understand why, as things change, you may be changing the policy. So you should have a vaccination policy in there. If you're mandating vaccines, your policy should say how exemptions are available, which exemptions are available, a masking policy, what kinds of masks are acceptable in your workplace, when they can be removed, when they can't be removed, restrictions on gatherings. So some companies have moved to a no meeting in person situation during Omicron that maybe will lift as this wave subsides. Instructions on how to report cases. So if somebody has reported to the work site, they get COVID, how do they report it to you so that you can make sure that the coworkers are protected, and instructions for how to return once they have recovered from their COVID case. So at the end of the day, it's all about communication. If you don't communicate it, you will definitely have dissatisfied, disgruntled employees. At this stage, there's probably no way to make all of your employees happy with your policy, but you can make sure that they at least know what to expect. And that really does improve the ability to work with them if something comes up where there's an issue where they have a problem with part of the policy. And then, coming off of that, writing the policy itself it really can be helpful to have a team that works together to create the policy and have people from across different parts of your company be on that team, because they may be aware of different concerns than you're aware of. And then I would just say with that, somebody on that team should be in charge of reviewing jurisdictional requirements. We can help you with that at 650 if that's your multiple jurisdictions, and create a clear line of authority if one doesn't already exist. Just being part of the team that helped create the policy doesn't make you a person that employees should be reporting to if they maybe have a COVID case. It needs to be clear, and people need to know who made the decisions, but who they need to go to if they have an issue. So those are, I think, the biggest takeaways for going forward with our COVID policies into the future.
Thanks, Marie. We have had a ton of questions. We have answered almost 20 of them just through typing up answers, but there's still a couple that remain. We have 3 minutes left. Maybe we could touch on one issue that seems to run through a lot of the questions, and it's what should businesses do if they either have a base in one state but have remote employees in other states as far as their vaccination policy? And I think you touched on that. And then another one is, what should they do if they're sending employees to other states for conferences, business meetings, or the like? How do businesses confront those two types of challenges?
Yeah, I think that's such an important question right now. In terms of the policy itself, if the company is in one state and your employees are in other states, as a general rule, the law that applies to those employees is the employment law of the state they are in. So wherever the employee is working from. So you do need to be aware of where your employees are. If you've let them sort of like go off on their own during COVID, you need to figure out if they've actually relocated to a new state and new state laws might apply. So that can be really important. And my thoughts, and I'd be really happy to have y'all's thoughts on the second part of the question. I think that if you're looking at sending people to a state where, for example, you want to send them to an event in New York, and in New York, they have to show a vaccine card, to be able to go into certain venues. If they're not going to be able to do that, they shouldn't be your company representative that's going to that event. And so with the exception of Montana, where you cannot ask, you need to go ahead and find out if they're vaccinated, even if you're not requiring them to be vaccinated. If you're looking at having them travel to one of the other states for you. If you're in Montana, I hope you're in a second state, so you have representatives from another state that you could send in those situations. I'd be really interested to find out what you guys think in addition to my thoughts on that.
Well, and I think this is a hard question. One of our questions actually touches on a situation where you have employees whose job is to attend these types of events, to attend trade shows or conferences, and because they're not vaccinated, they're not able to do that. And I think that puts businesses in a tough spot because those individuals aren't able to comply with a requirement of their job because they're not vaccinated. And I think in that situation, frankly, I would recommend that you consult with a lawyer, most likely, because I think that's a really difficult determination. But that's the kind of situation that I think businesses are facing.
Yeah, and I would say, reasonable accommodations law, part of it is that the person can fulfill the job responsibilities with some small accommodation. So if it's a very specific part of the job duties and they can't fulfill it, then it would be considered, essentially beyond the requirements of making a reasonable accommodation to allow them to have that role.
Yeah.
Which is why you would definitely want to consult a lawyer.
Yeah, definitely with that question. Well, we've reached our hour mark. I want to thank everyone for joining us on this webinar. We do have a couple of open questions. We've answered almost 20. We haven't gotten to everyone. We'll answer those and send out the answers with a follow-up email that will include a recording of the webinar. But we want to thank everyone for joining us. If you have questions about whether we may be able to help you at 650 with these types of issues, feel free to visit us at www.sixfifty.com. And please join us for future webinars. We plan to continue to have webinars about these types of topics, as well as privacy and other topics. So thank you for joining us. Have a great and safe day, and we look forward to seeing you at a future 650 webinar.